Welcome to Employment Law This Week. I'm George Whipple. Happy holidays. In this, our final edition of the year, we're taking a look at the top 5 employment issues of 2017. Paid leave goes local. 2017 saw the passage of a slew of new state and local paid leave laws, many of which go beyond what is required under the Family and Medical Leave Act. Employers in those jurisdictions may find that their own policies are not in compliance with these new laws, even when they are more generous than what is required under the FMLA. New laws include amendments to the California Family Rights Act, universal paid leave in Washington, D.C., and paid family leave in New York State. Nancy Popper has more.
We've seen with the new paid family leave laws pay associated with leave laws. Previously, they were unpaid leave. We've also seen expanded reasons for the use of this type of leave, not just for one's own serious health condition, but also to care for family members like grandparents and grandchildren. The federal FMLA also only provides leave for employers with 50 or more employees. These new state and family paid leave laws are providing leave for much smaller employers.
Pay equality on the march. Continuing a trend that began in 2016, we saw a lot of activity this year around equal pay. Approximately 100 bills were introduced this year in over 40 jurisdictions. Most legislation centered around 3 major actions: expanding equal pay regulations, banning questions about salary history, and increasing transparency around pay. The trend is likely to continue next year, including on a federal level, where the EEOC has made ensuring equal pay for all workers one of its top 6 priorities. #MeToo. Sexual harassment scandals in entertainment, news, and politics were at the forefront this year, and the Me Too movement made it clear just how universal the problem is. Employers that fail to take affirmative steps to prevent harassing behavior or respond to allegations of harassment risk exposure to EEOC charges or litigation. Recent studies indicate that less than a quarter of employers have reevaluated the risk of sexism or harassing behavior, but we expect those numbers to grow in 2018. Increasing threats to cybersecurity. 2017 brought us the Equifax security breach, one of the worst data thefts in history. Data security has never been more important or challenging. Some vulnerabilities employers should consider are lack of stringent remote access management, a failure to regularly assess risks, and the absence of an insider threat program, since most data breaches come from employees or trusted third parties. And finally, big changes in wage and hour enforcement. Labor Secretary Acosta has withdrawn the joint employer and independent contractor guidance and has announced a return to the practice of issuing opinion letters. The DOL was enjoined from enforcing new regulations, more than doubling the minimum salary for white-collar overtime exemptions before the regulations were finally withdrawn. Acosta has also proposed rescinding some limitations on tip pooling, and the stage is set for even more changes in 2018. Paul DeCamp tells us what we're likely to see in the coming months.
We're going to see a decision from the Supreme Court on the enforceability of these class waivers and arbitration agreements. We will get clarity almost certainly on the issue of what will be the salary threshold for the executive, administrative, and professional exemptions. And then we're also going to see where exactly is the Department of Labor going in its enforcement policy in terms of how it handles investigations, imposes penalties, seeks liquidated damages, and that sort of thing. So we're going to see more guidance about where the department will be in its enforcement.
And that's it for a very busy year in employment law. Thank you very much for watching. Here's wishing you and yours a wonderful holiday season and a very happy new year. We'll see you in 2018.